just like to welcome you to our first attempt at doing a webinar.
Thank you so much, Lisa. It's great to be here, and I'm really thankful for the opportunity to be able to be the inaugural guinea pig on the webinar for EISF, and also to discuss this topic of counterterrorism and the impact of counterterrorism measures on humanitarian action. In particular, I want to really emphasize that I think our discussion should try to find the areas where this topic is relevant to security focal points and security actors within humanitarian organizations. Overall, of course, I think this topic is relevant to those working on issues of security, but I think there are also some areas where we can kind of hone in on the salient points. First, I'm just going to talk about the relationship between counterterrorism laws and counterterrorism policies, and policies and principles underlying humanitarian action. I know some of you are familiar with this topic and have heard presentations on this before, but because it can be quite a complicated arena, I do want to make sure we cover just the basic core tension. I think it's always useful to kind of remind ourselves about sort of why are we talking about these two areas of law and policy that often seem quite distinct from one another. And then I'll get into kind of a few of what we see as the pressing topics at hand today. Counterterrorism clauses in humanitarian grant agreements, partner vetting systems, and other vetting systems that may pose unique security risks in environments where listed armed groups control territory. Let me say a word about myself and my project for those who are not familiar with it. My name is Naz Modirzadeh. I'm a senior fellow at the Counterterrorism and Humanitarian Engagement Project at Harvard Law School. We are a Swiss-funded research and policy program that focuses on the relationship between international law, international humanitarian law, particularly that focused on humanitarian assistance and humanitarian access, and the relationship of that set of laws to counterterrorism laws and policies, either at the international level, put forward by the Security Council and the General Assembly, or at the domestic level in terms of criminal material support laws and other laws prohibiting support to terrorism. We work with a number of UN agencies, humanitarian INGOs, and governments in trying to identify operational and legal dilemmas that come out of this intersection. And some of the research I'm going to be talking about today is from a Norwegian Ministry of Foreign Affairs funded research project supported by NRC that looked specifically at counterterrorism-based clauses in grant agreements and the measures taken by humanitarian organizations to comply with those clauses. I'm happy to talk about that at greater length if it's of interest to some of you. I'm going to focus in on a few areas of the law, and then we'll move into some of the more practical implications. But I want to give you a sense of sort of the legal environment in which the practical implications are being found, and the strength of the law that is affecting humanitarian operations. The sense that governments appear to have that right now, at least, counterterrorism laws and counterterrorism policies are a real priority in terms of regulating financial flows, operational decisions, and funding for humanitarian aid and development aid. So I'll look at Security Council, and then I'm going to use the U.S. as an example, but as many of you are aware, we've seen a increase in counterterrorism, criminal, and other laws in a number of countries. Certainly the UK and Canada appear to be closest to the U.S. in terms of the rigorousness of their laws and their appetite for ensuring that those laws are passed down to grantees that receive government funding. But we've also seen these laws developing in other states, and there is now a good deal of research going on host state regulation. So governments that have humanitarian crises on their territories and are the recipients of not just a considerable amount of funding, but also humanitarian operations. We've also seen a marked increase in those governments developing domestic counterterrorism regimes. So I'll just take a little bit of time to talk about sort of the legal environment, and then we'll move to, as I said, some of the more practical implications. At the Security Council level, the most important two resolutions for our purposes are 1267 and 1373. 1373 is a resolution that essentially tells every UN member state under Chapter 7 authority, so under the most powerful lawmaking authority of the Security Council, that they must have domestic counterterrorism laws that limit the flow of resources to terrorist organizations and seek to name certain groups as terrorist groups. The important aspect of this resolution is to understand every government on the planet is required to implement counterterrorism laws in its domestic legal regime. 1267, and there are a series of sort of children of 1267, but 1267 is a dynamic Security Council maintained list of organizations and individuals that are named as being affiliated to or part of Al-Qaeda. 1267 was initially an Al-Qaeda and Taliban list. The Taliban list has since been broken out, but 1267 is on a weekly basis changed. So it can be added to, and individuals and entities can be removed from the 1267 list. But the importance of this list is, again, Chapter 7 authority. Every UN member state has to ensure that anyone on the 1267 list has a travel ban imposed on them, so they cannot travel internationally, and in many cases internally within the boundaries of a state, and an asset freeze. So their bank accounts, their access to resources must be cut off by the state. Just to give you a very recent example, you may have seen some 8 days ago or so now, the Security Council added the Nigerian group, often called Boko Haram, a shortening or a slang version of their title, armed group in Nigeria, to the 1267 list as an Al-Qaeda affiliate. So we'll get into this, but this has immediate practical implications for humanitarian organizations, and certainly has immediate practical implications for governments, your donors, and where you are working. Every government that day had to do something about the fact that Boko Haram had been added to the list. I should note there is now a mechanism by which individuals can be removed from this list with an attempt, I think, by the Security Council to provide additional due process and respect for human rights of individuals who may have been wrongly added to the list. But for most of the groups we care about, that does not appear to be the issue. Second, in terms of domestic regimes, so this can be either states that are seeing their obligations under the Security Council resolution and saying, okay, now we're going to create our own domestic counterterrorism system modeled on 1373. So this is what you often see in European states, is that they are looking at their Security Council obligations and they are creating a domestic counterterrorism regime largely modeled on that. Or you can have states that go far beyond the Security Council's requirements, and the United States is an excellent example of that. But it's important for us to understand U.S. counterterrorism law is the model that is being used in shaping the counterterrorism laws, regulations, and enforcement approaches of many, many states that today have humanitarian operations occurring on their territory. So this is Australia's listed terrorist organizations. So this is Australia saying, we have an obligation under Security Council Resolution 1373 to have a domestic counterterrorism legal system, and we've been encouraged to create a domestic list. So some countries will say our list merely mirrors the Security Council's list. That is I would say, a diminishing number of countries. Most countries want to have their own domestic list, which may reflect threats to their nation in particular. There may be organizations that really have identified one country as the primary target of their terrorist activities, or it may reflect domestic political sensibilities that could be different from others. One good example of that is the United States has long held that Hezbollah is a terrorist organization. The UK, Australia, Canada, and now the EU may consider Hezbollah's armed branch as a terrorist organization, and many other countries don't consider Hezbollah to be a terrorist organization. So that's something where countries may have different approaches. So this is Australia. This is Canada. So you'll see this is a longer list. And we have groups here that are not on Australia's list. And again, if you are receiving Canadian funding, or if you're an organization that's either based in Canada or has branches in Canada, it would be important to look at this list and remember that these lists change. So Canada recently added the Taliban to their list, and Hamas was added not so long ago either. So you may see this changing. I do want to point out here, by the way, you could have countries listing state entities in their terrorist list. So if you look at this list in the middle, you have the Islamic Revolutionary Guard Corps Quds Force. That is a branch of the Iranian government that is listed in the terrorist list. So again, states can be quite peculiar as to how they do this, and it does differ from state to state. U.S. Foreign Terrorist Organization list, again, even longer than the Canadian list. As you'll see, it has a number of Al-Qaeda branches broken out. This was changed about a week ago, and we are seeing this more and more as we observe these trends. The United States announced that it was listing separately the Nusra Front, or Jabhat al-Nusra in Syria, and the Islamic State in Iraq and the Levant, or the Islamic State in Iraq and Syria, ISIS or ISIL, in recognition of the fact that those groups had now broken from one another. So again, states are really paying attention, and they're making these lists very responsive to facts on the ground. United Kingdom is the next one, and we'll see how this all comes together in a moment. Keep in mind that these lists all are tied to different domestic legal regimes, right? So in the United States, the terrorist list is the basis for the statute prohibiting material support to terrorism, right? So the U.S. statute will say material support to foreign terrorist organizations, and that's telling you you need to look at the U.S. Foreign Terrorist Organization list. In the United Kingdom, the Terrorism Act will make reference to the prescribed terrorist organizations list and will tell you these acts that are prohibited vis-a-vis the groups that we have listed here. Again, if we look at the UK list, you have a number of Irish-related groups that, of course, are not going to be found on the Spanish terrorist list, right? At the end, you'll see the Ulster Defense Organization, the Ulster Freedom Fighters, and again, this is going to change over time. There are going to be some organizations that will come on and some that will be taken off. So let's talk a little bit about practical implications. There are a few, and I know that we got some questions and comments in advance that I think touch on some of these issues that I'll be very briefly addressing. So the first possibility, perhaps the most promising possibility, is to say, okay, there's a tension here, sure, but it's not meant to be a tension. So the logic here is the states that put forward these counterterrorism laws and policies and the Security Council that promulgated resolutions like 1373 were not thinking about humanitarian assistance when they made these regulations. And that their primary target was banks, individuals using front or cover organizations in order to launder funds and get them to terrorists, and people who want to support terrorism, right? That's their main goal, not MSF, not IRC, not SAFE. In that model of thinking about this problem, the best, most effective way to solve the tension that I've just illustrated is to create exemptions. So for many of your organizations, the one very practical approach is to say, we see that we are working in, let's take Somalia, right? So Al-Shabaab has been listed by the Security Council as a sanctioned organization, not as a terrorist organization, by the way, as a sanctioned organization. The United States has listed Al-Shabaab as a terrorist organization. We look at this slide set or some other resource, and we see that that creates all kinds of prohibitions for assistance to, a benefit to Al-Shabaab. That's one fact, and we know that. Number two, we see, and there's so much evidence of this now, there was a time when saying this was a bit controversial. I don't think it's particularly controversial anymore to say that we know that organizations that were, and in some cases are active in South and Central Somalia in territory controlled by Al-Shabaab found themselves being told, you have to pay a tax, you have to pay a registration fee, you have to give us something if you wish to continue operating in the territory we control. So that's another fact. Right, so let's say, for purposes of our discussion, a $500 registration fee. Not at the end of a gun, not some coercion as such, but a clear quid pro quo. We need this registration fee if you want to be able to operate in the area that we control. Okay. And the third fact is we have millions of dollars from donors and urging from the Security Council to get humanitarian assistance to the population in Somalia, the worst hit areas being in areas controlled by Al-Shabaab. One approach is the one you see here on your screen. It is an exemption, a carve-out, it was often called, that was created in 2010 by the Security Council, particular to Somalia, that said that those organizations, it was UN observer status, organizations, so UN agencies and programs, their partners, and then those with observer status like the ICRC, were exempted from the sanction that was being imposed by the Security Council for purposes of delivery of urgently needed humanitarian assistance. So one possible way to deal with this situation is to start pushing for more exemptions, essentially to tell the Security Council and governments, every time you create a sanction or a counterterrorism law, you have to put in that proviso that this is not meant to affect or regulate humanitarian action. And let me show you what this looks like in domestic law. This is the New Zealand exemption. This is incorporated into all counterterrorism law. The offense of providing support to a terrorist organization is drafted to exclude humanitarian assistance to a designated terrorist individual. And let me show you what that looks like in a potentially American context. This is the Humanitarian Assistance Facilitation Act, also called HAPA, which attempts to do a New Zealand-style carve-out to the law as such. Right? So this is a big, big topic of debate right now within our community. Is it a good idea to push for these kinds of exemptions? If they are successful, they would essentially reframe counterterrorism laws to recognize that humanitarian assistance has to be exempted. But I want to talk for a minute about vetting. So if I were to sort of list off kind of topics of hot debate in this area right now, one would be the exemptions, the drive for exemptions, the question of exemptions. Two is the issue of vetting. So in my personal view, for security focal points and security actors in particular, this is where this issue is practically going to matter for you. And this is an issue that may not be brought to your attention. Our research looking at how organizations operate internally indicates that communication even within organizations is often very weak on this issue for a variety of reasons. It's sensitive, it's hard to talk about. Many times we don't even know that there are counterterrorism regulations that may apply to our organizations. But let me say, and again, this is my personal view, and I don't at all mean to suggest that everyone should agree with this, but my perspective is if we were going to draw out one aspect of this that has real, possibly immediate security implications, it would be vetting. So vetting overall is a requirement that you may often find in grants, clauses, other agreements that your organization signs. And it is essentially a requirement that says grantee, let's make up an NGO, right? So let's say Good Food NGO gets a contract and it says Good Food hereby agrees that in their operations in Somalia, they will vet all staff, partner organizations, contractors, and vendors against the 1267 list and the Canadian terrorist list. Let's say this is money coming from Canada. That's simple vetting, right? So that, as you can imagine, already creates possibly some real questions for us to think about from a security perspective. Who in your staff is going to be tasked with doing this vetting? Will they tell the partners, vendors, and contractors that they are doing this? In a particular context like Somalia, is it safe to inform partners and vendors that you are running the names of individuals against a Canadian, or put the word Western in, or put US in, terrorist list? Do you need to have a plan for how to explain to those partners, vendors, and contractors what you're doing with the names that you're putting into the terrorist list? So I've heard more than once from NGOs that staff believe that the vetting software is owned by the Central Intelligence Agency and that the CIA is actually using vetting to collect names. And in the current climate, that may not be a completely ludicrous concern. More complex, you may have governments, such as the United States, that's going much farther than that vetting that I just described to require that grantees actually collect detailed personal information on key personnel within the organization, so your staff, and key personnel of partner and subcontracting organizations, so the local NGO that you work with in Syria or Turkey, and to give that information directly to the USAID. Not vetting yourself against a list, but rather sending all of that information to USAID. Given what we know about, for example, attacks on polio um, vaccine providers in Pakistan in what was referred to by the groups that were carrying out these attacks as a direct retaliation for the involvement of medical vaccination programs in the effort to find Osama bin Laden. What do you do with this requirement? And how do you think about this from a security perspective? And what does the conversation look like within your organization when this kind of requirement is imposed contractually? Finally, I do want to suggest, and I think I've talked enough about sort of the possibilities of legal requirements, but there's also, of course, reputational harm. And for many organizations, this may also be a security issue, right? There's the immediate security concern of what does it look like for us to go to the trucking company or the warehousing company and ask for this kind of detailed information. But there's also the concern about what if an interest group creates a website saying your organization is providing support to terrorists and is able to use applicable law in order to bolster that claim. We've seen this happen. World Vision Australia was accused by Shurat Hadin, the Israel Law Center, of providing material support to a number of proscribed Palestinian groups, and a pretty impressive public relations campaign was carried out across a number of countries, ultimately leading to a formal investigation by the Australian Parliament into whether or not AusAid had made mistakes in funding World Vision Australia. The findings of the investigation were not at all that all groups had acted appropriately and that AusAid had monitored its funds appropriately, but this was at a significant cost to World Vision and its partners, and delayed the provision of assistance for some 6 to 9 months. So the costs of this may well be more strongly felt on the practical side than on the legal side. It's unlikely that humanitarian organizations at this time are going to be prosecuted in droves by the United States or the United Kingdom or Canada today. We haven't seen it. But it is perhaps much more likely that either at the field level or at the headquarters level, organizations are going to find themselves coming under increasing scrutiny and having to think about this issue not just at the level of your lawyer or your head of HR, but also at the level of security and what it means to think about this issue from the perspective of security actors.